speaking, with me Tarun Nangia. Today is a very interesting day because today we begin a new series. That series is aptly titled Saturdays with Sikri. This is a series with Justice Arjun Kumar Sikri, where we have long-winded conversations on the most interesting subjects, where you will get to see Justice Sikri sharing his insight on these issues, which I am sure my viewers will find it something which is very wholesome and what they would like to watch. My first topic is something that comes to my mind when I think of Justice Sikri is the topic of arbitration. And the good note today is that Justice Ramana, the Chief Justice of India, said the International Arbitration Center in Hyderabad will start operations on December 18th, which is just a few days from now. So first of all, let me begin by welcoming Justice Arjun Kumar Sikri and in a sense thanking him for joining us for this series.
Thank you.
So my first question is, you would have seen that Justice Ramana made a comment. All prudent people will leave aside egos and embrace practicality if quick and effective dispute resolution platform is provided. He said this in the context of the institution in Hyderabad. Why do you think we need arbitration institutions is my question. And why do you think Justice Ramana made that comment?
See, Mr. Tarun Nangia, it's a very interesting question and important question to understand the implication of the statement which is made by the Honorable Chief Justice of India. As we all know, arbitration is an alternate mechanism of resolution of disputes, dispute resolution, because the main system is the court system, where the parties, when the disputes arise, they go to the court and have their disputes settled. But at the same time, arbitration has prevailed, not only in this country, but world over for centuries. It is in a way hybrid system, to which I'll come to. But to tell you in nutshell, and to those who may not be lawyers or belonging to legal community, so it's a mechanism which is outside the court, where the two parties who are at dispute with each other, instead of going to the court, they think that we should go to this person. The person can be appointed and nominated by them, and they can say, okay, you go, and we are going to him and or her, he or she should decide our disputes. I give you a simple example. Suppose there are family disputes between two brothers. They say, okay, let us go to our uncle. They enter into a formal agreement that yes, whatever our disputes are, we go to our uncle, and whatever he decides will be final and binding on us. So this is in the form of, this is called arbitration. If it is regulated by, we have Arbitration Act, which regulates the regime. Arbitration ultimately is a hybrid system where court's role always comes, because even if in the example which I have given, uncle has decided the dispute. If the parties act upon that, the award which we call in the court, when it is decided, it is in the form of a judgment, and the arbitrator who gives his decision, it is called an award. So that award is deciding the same thing. It's also an adjudicatory process like in the court, but by a private person. And once that is decided, now the question is, if suppose one party doesn't implement that, or is not inclined to implement, what is the remedy? That uncle cannot enforce it. For enforcement, one will have to go to the court. So courts come in. And many times there are parties may, even before, at that time disputes have not arisen. Suppose some contract is entered into, any collaboration agreement, any other contract between two parties has been entered into, and this is a common practice. They say that if disputes arise, we will have an arbitration. It will be decided by. Now, in that they can, and so therefore we call it a system where party autonomy is there. The parties are the deciding factor who should decide. Instead of, if you go to court, which court it will be gone into, they can't decide that, they can't choose that my case should be decided by X judge or Y judge only. That's a court system. But here they can think of that. But then it is not, it doesn't happen always that they name the person who should decide. In that, there may be a mechanism would be there. Normally, it happens that, okay, if dispute is arises, it will be decided in such and such manner. Now, when it comes to the appointment of the arbitrator, it can be, they can say, okay, we will nominate one of us, one you nominate at that stage, one I'll nominate, and the two arbitrators will nominate a presiding arbitrator. This will be the arbitral tribunal. Or it can be a sole arbitrator, you say one person, but then who should that be is not there. Then in that case, Arbitration Act provides that a person, if they are not, when the disputes arise and they are not able to decide who should be the person, they can go to the court and court appoints. So this is called ad hoc arbitration. In each case, separately court appoints. Now, vis-a-vis this, there are institutional arbitration where there are institutions who conduct it. And in the agreement, I can write, okay, if dispute arises, the two parties agree, we will go to, like we have Delhi International Arbitration Center in Delhi High Court. We'll go there. We have Indian Council of Arbitration of FICCI, that, okay, we will go there. Or we have international the centers like Singapore International Arbitration Center, London Center of International Arbitration, or ICC Paris, etc. These are the centers. They can name there. So therefore, there are two kinds. One is ad hoc, where nothing is said. Court appoints, court may appoint, okay, Section 11, disputes have arisen, we are appointing. I appoint Justice so-and-so, retired judge of the Supreme Court, as the arbitrator. This is ad hoc. In the second case where I've said, it is the institution arbitration. But then your question was, what is the importance of an institution arbitration? Now, insofar as ad hoc arbitrations are concerned, of course, the arbitral tribunal which is constituted, whether by the two parties, when they say, first example which I gave, that they nominate two persons, each nominates one person, and then they appoint the third as a presiding arbitrator or chair. This is also ad hoc. They have appointed. They have not gone to any institution. But then they would, the arbitral tribunal will act in accordance with the provisions of the Arbitration Act, which says the procedure. But then there are many things which are not there, which the parties have right to decide, or the arbitral tribunal, arbitral tribunal with the consent of parties, or if they are not consenting of its own, what should be the procedure, what should be the fee. If fee, we have fourth schedule under the Act, but if it is not, that is not agreed upon, then the arbitral tribunal will fix, and all those things. So all those are the loose ends, which in a given case, the arbitral tribunal will be taking a call, how I have to proceed and how it is to be done. On the contrary, when it comes to the arbitral institution, they have their definite rules under which the entire the arbitration will be governed. It will be under the aegis of that arbitration center. They will have their secretariat. They will have their, the supporting staff, which will be, and it is in that way structured, and even fee, etc. Everything is fixed. All these things are taken care of. So therefore, it becomes little more scientific and little more systematic and methodological. Now, there are certain, I would say, shortcomings of ad hoc arbitration. Some I have pointed, but then what happens is that many times under the this ad hoc arbitration, and we have seen in India particularly, now this scenario is changing in last few years, but what we have seen, it was a part-time practice of the advocates. So 10 to 4 I have to be, or 10:30 to 4 I have to be in the court, and in the evening I'll have one arbitration, and I'll go and I'll tell the arbitrator to fix my hearing only at 4:30 or 5 o'clock in the evening. We used to call it a 5-star culture, that you go to, you have a hearing in a, you get some conference room booked in a, say, Oberoi or any other 5-star hotel, and you hold it. Of course, of late now we have certain places which have come up which provide such facilities. We have one in Niti Bagh also, which is the Niti Bagh Club is providing. But then they are only providing the space. They are not the institution as such. But then what should be the fee? The main purpose of the arbitration is, apart from, as I said, party autonomy, it is confidential. And the main purpose is, which was the purpose behind the Arbitration Act, that it should be cost effective and it should be speedily, the case should be decided. So speed and cost. But over a time, it was found that in ad hoc arbitration, this purpose is not achieved. But most of these things can be taken care of if institutional arbitration is there. So therefore, the importance of institution, if I may say in brief, and that is why institution should be there, and that is why there are so many institutions which are coming up.
I want to know 3 quick things from you. Justice Ramana said that people should embrace practicality and go for arbitration. It also leads that the court's pressure will take off in India's enforcement of contracts will greatly improve if what Justice Ramana said happens. But now the problems, we don't pay world-class fees to our arbitrators. Same dispute in India, we pay less money. In Singapore, we pay more money because Schedule 4 fixes a lower amount of fees. Even our institutions pay lesser fees. So why would world-class arbitrators come to India to earn less? Why would any good arbitrator not want to arbitrate in Singapore? That is one point, that A, arbitrators are not paid what they should be paid. Second, we have had some institutions earlier in this country, but still we don't have an international arbitration center of repute, which is globally known. Justice Ramana may have a wish that Hyderabad emerges as such. Do you think there is a possibility there? And on the fees aspect also, do you have some thoughts which you can share with the audience?
Yeah, I'll come to the fee part later. First, let me address the second question which you have asked out of these 2 questions, is about the arbitration centers, etc. Now, I tell you, in India, many centers have come up, no doubt. We have ICA, as I tell, of FICCI. We have Delhi International Arbitration Center, which was set up by Delhi High Court, and it is in the premises of Delhi High Court itself. Likewise, certain such institutions have been set up by in the other high courts also, and there are few more institutions also which are coming up well. But what is, as you rightly pointed out, all these institutions are having good work insofar as domestic arbitrations are concerned. Now, domestic arbitration means where both the parties belong to India, and it is, but not international arbitrations, where one party is Indian, one party is of the other country, or maybe both parties belong to other country. Now, institution like Singapore International Arbitration Centers, SIAC or SIAC, they are attracting where the parties, one party may be, say, of China, other party may be Indian party, and there is a dispute, or say Hong Kong, India, or Germany, India, even from some Western, they'll say, okay, if dispute arises, we'll go to SIAC. So this kind of, we have not been able to create that kind of atmosphere in India. And there may be many reasons. One, you are saying about the fee, etc. Of course, when the institution is there, the fee which is under the Arbitration Act, 4th schedule, is for ad hoc arbitrations.
Yes.
But when it is under the like DIAC, which I have given the example, ICA, etc., they have their own fee structure. But there also, you are right, most of these are having the same fee structure, which is 4th schedule. It is almost practically they incorporate that only. Where I know, like Mumbai International Arbitration Center, which was set up, their fee structure was little better. And to my surprise, it was even shade better than what Singapore has fixed. But they were not able to attract much, particularly international arbitration. I don't think even a single arbitration. So there may be, as far as that is concerned, maybe various other reasons. Now, once we, in legal parlance or technical, this terms are there, we call it venue of arbitration and seat of arbitration. Venue of arbitration is if it's a center is situated, like we are saying, with Chief Justice inaugurated in Hyderabad, that becomes the venue of arbitration. But if we say that the law of the Indian law will be followed, and the substantive law or procedure law, which is Arbitration Act, then it becomes, or if it is stated in the agreement, then it becomes the seat of arbitration. So in most of the cases, seat of arbitration in international dispute, it doesn't happen in India. Apart from many other reasons, one reason could be for enforcement. Once the award is passed, suppose seat is in India, and suppose international arbitration comes here, and award is passed by the arbitral tribunal constituted under the aegis of that center. Now, it has to be that if it is to be challenged, somebody wants to challenge or it has to be in the Indian court, if seat of arbitration. So many have this fear, two-pronged as far as judiciary, although that, again, the impression which was there earlier has been waning in last few years. And fortunately, because of the progressive judgments which are coming in last 8-10 years of the Supreme Court of India, that impression is removed largely. That is that Indian courts interfere with the awards too often.
Yes.
So therefore, what should be the approach of the courts? They are not arbitration friendly in the sense, yes, they will. So the justice or the zeal of the Indian judges is no. We have to do justice in the matter. If we feel no, it's not that they wrongly do. They say that if in this case injustice is done, we have to set it right. The award doesn't appear to be a good award. But what is to be seen is, when the party autonomy is there and the parties have left to this, then the courts are not sitting as appeal courts. It is only on very, very limited grounds that the award can be challenged, which are provided under Section 34 of the Act.
Yes.
But as I said so therefore, that was one reason that the other parties from the other country would not come. So if the award is passed here and then thereafter challenged here. But other reason, which still, as I said, this may be, this impression is removed to large extent. That is what we are becoming. Other reason could be that, and which is there, which I say, delays. Even if it is for, if challenge to the award or enforcement of the award, it may take years in Indian courts. Yes. So they think, even if suppose I have got the award in my favor, and the other side is challenging that in Indian court, I will not be able to get the fruits of that award if that is stuck in the court process for 5 years or 7 years. So why go to India?
Yes.
So therefore, these may be some of the reasons. There are other reasons also, and which we can discuss over a period of time. But by and large, what I say is that it is the judiciary, the government, and the institution which have to work in tandem and to promote arbitration culture in India, to tell the world at large that India is an arbitration-friendly country. Come here and you will get not only but from this institution award speedily, which will be cost-effective, but at the same time, it will not get stuck in the courts as well. If that kind of impression is created, which Singapore has been successfully able to create in last 10-15 years. Maybe, we may become an international hub.
No, since you're almost out of time, my last question to you. Our Chief Justice of India, Justice Ramana, made an endeavor with the Hyderabad Center. You have said that the courts must also step in and encourage arbitration. Do you think if the judiciary, in a sense, and all Chief Justices of all high courts, including the Chief Justice, think alike and get together in the next 4 or 5 years, then India can have at least 1 or 2 institutions of excellence? Because when the court system starts to support arbitration is when India truly will see the golden days, and a lot of business of arbitration will increase,
Yes, Tarun, you are right there. What happens, as I said, I give you a very interesting, I narrate that anecdote. It must be in 2005 or 6. some of us, few judges and advocates were invited by Singapore International Arbitration Center. 15, 16 years ago, the way it has prospered now, it was not at that time. And we had a discussion, followed by we visited SIAC, but that discussion was there. So there were 3 speakers from India, 3 speakers from their country. From India, I was there. Justice Lahoti, I still remember, was there. And there was one senior advocate, I think most likely Mr. Amarjit Chandok was there. Now, we kept on saying what our laws are, how arbitration, etc. And on the other side, when the speaker's turn came, there was one Supreme Court judge. There was from one SIAC, the CEO, and there was one from the government. I think he was the Attorney General was there. They spoke only in one language, all 3 of them. Come to Singapore, we are the best. So this was the way that they coordinate, how they coordinate with each other. And as I'm telling you, not in detail, but this was the one message. Look, all 3 of them were saying, from government point of view, from judiciary point of view, from SIAC point of view, look, our system is the best, come to us and we'll give you the results. So that kind of cooperation has to be there among us. Like if you give, as you very rightly said, I read it in the newspaper about that Modi's case. Lalit Modi and his mother's dispute. Yes. And Justice Ramana said that why you want to go for arbitration and other thing, go for mediation and go to our center. So this is how he could encourage them to come to. So if successive chief justices and other judges also start doing in this, but the question would be this again, both are, what we have to keep in mind is that maybe Lalit Modi today is not in India, but both are Indians. And the Chief Justice or the Supreme Court is saying they would abide by that, agree by. But question is willingly, whether the persons from other countries come or not. I will only try to say only in 2 minutes, 1 or 2 minutes. There are many, many things which are required to create an institution of international repute. And if we study the model of ICC Paris, LCIA, Hong Kong Center, SIAC, etc., we'll come to know. One has to have very good rules of arbitration center. I'm only flagging because there's no time to give it. Yes. We have to have good panel of arbitrators, and these arbitrators should not only be from India, from all over. This is what I'm saying is this is all done by them. It has to be managed by the Secretariat, which is again persons from all over. And experts, CEO, who is the head, he or she should be an international expert because they are able to generate that kind of goodwill. Then infrastructure has to be, infrastructure which should be state of the art in every form. And because the kind of work which they have to do and to create that kind of goodwill and all these are some of the aspects which are very, very necessary. So therefore, and the center has to be at a place which is accessible very easily. Why DIAC kept it in the High Court? It had a great advantage. Okay, I'm a practicing lawyer. I'm appearing in the High Court. Immediately, I finish my case. Within the same building, I go and start appearing. If I have to go 20 kilometers away, I may think that, look, 1 hour going, 1 hour coming, my area of practice is High Court, Supreme Court. Why it should not be around that? So all these things matter. And therefore, if Chief Justice wants Hyderabad Center to really come up, these things have to be taken care of. And I suppose that as far as CEO is concerned, yes, they have taken one person, I think Mr. Tariq Khan, I have heard somewhere, and he is in what capacity, secretary or somewhere. He's a good advocate and good chap. May try to do and will try to do something. But then they need professional who professionally manage some centers.
Okay.
That is what I would say.
Thank you so much for sharing this insight today on our first episodes of Saturdays with Sikri. I'm sure that the larger corporate community would find the knowledge that you shared with him very enlightening. And also a lot of them in the judiciary and the legal profession who are taking up arbitration as their first port of call would also like it. Thank you so much for joining us on this first episode. Looking forward to a lot more on Saturdays with Sikri.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.